Mr. Gribble.
Thank you. Mr. Chief Justice Cady, Justices Christensen, Waterman, Wiggins, Appel, and Mansfield. May it please the court. This is an appeal from a decision of the Polk County District Court affirming a ruling of the Iowa Public Employment Relations Board. The case arose when the union asked IPERB to define the term base wages as it now appears in Iowa Code Chapter 20. The legislature had amended the law, and for non-public safety employees, which all of these employees are, they can negotiate as a mandatory subject on base wages. The legislature, however, did not define the term. The Public Employment Relations Board really defined the term in two parts. They said, first of all, base wages means only the right to negotiate a wage rate for the beginning or first step of employees. In other words, new employees, but not for anyone else. Second, the Public Employment Relations Board said that you could not negotiate the work to be done for the wage rate requested. It's from that decision that we appeal. The position of the union is that the interpretation of base wages must allow the union to negotiate a basic salary for each individual member of the bargaining unit, and we must be allowed to negotiate the work to be done for the wage rate requested. With respect to the first part of the argument, the unions here represent individuals, not job classifications. In order to be certified, they must win a majority of the individuals in the bargaining unit. They must also then, to retain representation, similarly receive the votes of more than 50% of all those eligible in the unit. Once certified, the union then has the right and the obligation to represent each and every member of the bargaining unit. And in prior cases in this court, you've held we have that obligation to do so. In Norton versus Adair, in Brown versus Sioux City, in Sergeant Bluff, they all involve the representation of teachers and where they'd be placed on a schedule, on a salary schedule. So with respect to IPERB's ruling, we are precluded from carrying out what the law imposes on us, an obligation to represent all. Contracts in Iowa are negotiated for a new fiscal year.
Let me talk about this base wages thing. As I understand IPERB's position, it is that, let's say, we'll use, say, law clerk, because that's a job classification I'm familiar with. So we have law clerks that work for us, and some of them have additional steps because of their experience level, some don't. Am I correct that what IPERB said is the base wage is what a law clerk who would be at step one would receive? Is that right?
Justice Mansfield, you're correct. That's right.
And isn't that at least a plausible interpretation of base wages?
Your Honor, we don't believe it would be. We believe that base wages must be given interpretation that allows the unit, the bargaining unit, who has the obligation to represent everyone, not just the first-year law clerks. Using your example, let's say they won a bargaining unit and had the obligation to represent everyone. They'd have the obligation to negotiate a base wage for all, each and every member of the bargaining unit.
But that base wage sets a floor for everybody, right?
No, it does not. The way that IPERB has held, the employer then, the court, in your example, could pay a second, third, or fourth-year law clerk less than a first-year law clerk. You could pay them the same, you could pay them more, but you could also pay them less, because under the definition that IPERB has, you can only negotiate that base wage rate, and that's it. And that's what precludes us from carrying out the responsibility and the obligation to negotiate that base wage rate.
I thought I saw the word minimum somewhere in the declaratory order, which I would normally say that minimum means that's what everybody in that job classification must get, at least that, right?
No, Your Honor, that's not the IPERB's decision. IPERB's decision is simply the base wage rate for new employees. If we use your example, or teachers, which I think most of us are familiar with, you can negotiate the BA step 0 or step 1, but you couldn't negotiate for those teachers with additional experience or additional credits. It would just be that BA step 0, and that's it. And the employer could unilaterally impose then whatever wage rate they desired on everybody else, whether it's law clerks or whether it's teachers. Then
I think I was confused too. Justice Mansfield's question is something that I thought was in the record as well. I think the ruling said PERB previously defined that phrase, base wages, to mean the minimum bottom pay for a job classification category or title. And this is according to Columbus.
Yes, Your Honor, that's correct. But if you look at how they've applied it, for example, I think that was in the case of Oskaloosa dealing with teachers, it was quite clear where they had the whole teacher salary schedule that they concluded you could only negotiate that base wage rate for those on the BA step 0, and that's it. And with respect to anyone else, you could not negotiate a rate. If it's not mandatory, then it's within the sole control of the employer. The employer can negotiate with the employee organization if they so choose, but they have no obligation to do so. And that's the problem. So for everyone else, they could pay them as much or as little as they desired. With respect then to that obligation, first of all, we don't think we can fulfill it. The reason is that the contracts in Iowa start July 1. You begin negotiations the prior November or December, and you must be complete by March 15th. At that time, under PERB's ruling, you could not negotiate for anyone in the bargaining unit, not a single person, because they'd all be moving on to the second step or beyond in the schedule. Now, there might be some individuals who have retired, resigned, been terminated, and theoretically you could negotiate for them, but it's doubtful you'd know who they are in the preceding November until the next March 15th, when bargaining must conclude. So you could really negotiate for no one or for some, at that time, non-existent, but prospective members of the bargaining unit, but for no one else. With respect then to the second part of the argument, with respect to, let's say you have a unit of 100, and you have turnover of 10, and you can negotiate a wage rate between November and March for 10 people. Now, usually you're not going to know who they are. You might not even know who's been terminated or resigned, but you can negotiate only that base wage rate. From there, then PERB said you can't negotiate the work to be done for the wage rate that you requested.
What I read PERB said is you have to, the employer has to disclose the work, disclose its position regarding the work to be done, because obviously a wage rate or a salary is meaningless unless you know for how much work we're talking about. Am I correct about that?
Justice Mansfield, you're correct in that that is what PERB said, but there's no support for that. Could request when negotiations commence to know those things that you're talking about. The number of holidays, the number of vacation days, the number of sick leave days. But PERB has also said those are all non-mandatory subjects of bargaining. So in the prior cases before PERB on this issue, in order to get that type of information from the employer, you first have to demonstrate that it is a mandatory subject of bargaining, that is a subject that the employer is obligated to provide that information to you on.
It sounds like what they're saying now is you're not going to be able to bargain over whether there's going to be 8 holidays or 10 holidays in a year, but we will tell you, or you have to, the employer has to tell you ahead of time how many holidays there will be, right?
That's what they're saying, Your Honor, but there is no support for that position. The prior cases really do with kind of a discovery standard where the employer does have to provide information to bargain, but only on those subjects that the employer is obligated to bargain on. And if they're not obligated to bargain, as PERB said, on holidays or vacations or sick leave, then similarly there's no obligation to provide that information. They may, but there's no obligation to do so.
Is that just a matter of case law, or is that something in the statute?
That would be a matter of case law, the way PERB has handled these cases in the past. They've said that, yes, the employer's obligation is to supply information needed to bargain, but if base wages is the only mandatory subject, then their obligation would be limited only to that particular subject.
This is a brand new world because they've changed all this stuff, and couldn't we put in this opinion that they have to disclose that information so you could figure out what you're bargaining for?
Your Honor, I don't know if the court has that power. Certainly that would be helpful to us if the court could do that and say that. But it appears to us from the case law that's existed with PERB that it would have to be on a mandatory subject of bargaining, that the obligation to provide information couldn't extend beyond the scope of the mandatory bargaining. They could do it, but we see nothing in the statute that would require them to do so, and nothing in the reported case law that would require them to take that step or take that action. But with respect to the second part of the proposal then, they've said, well, you can't negotiate, you said in Waterloo too, in order to rationally negotiate in any meaningful way a base wage rate, you have to know the parameters of the work to be done. Otherwise, you just can't do it. And you said it's only possible to rationally bargain, so you have those two words there. In this particular case, we have to know what work is to be done in return for, say, a salary of $35,000 or $40,000. And PERB said, well, you can't negotiate that because holidays, vacations, and so on are now all permissive subject of bargaining. So under our proposal, we're saying simply that you can't negotiate a separate article on vacations that may, for example, set forth the manner in which you take the vacation, the advance time in which you need to give, who goes first in taking the vacation. Do you have to use it all at once? Can you use it in one-day increments or an hour? We can't negotiate any of that. But we're saying as far as negotiating simply the number of days, we need to do that so there can be some meaningful bargaining with respect to vacations, with respect to holidays, with respect to sick leave. But we can't go further. We would certainly concede that. We can't get into a sick leave, like how long in advance do you have to request it, to whom do you have to make that request, do you have to have a doctor's note when you come back. Those are the provisions that would be in a sick leave article in the past in contracts that we've negotiated. We're saying we can't get into that, but that we can specify and must, in order to negotiate a wage rate, simply the number of sick days, vacation days, or holidays, in order to meaningful bargain collectively. So our position, and Judge Mansfield, going back to your original question, is that what PERB has decided is that you can only negotiate that base wage rate for the first-year law clerks or for a first-year teacher, but you can't negotiate for anyone else. That would mean it would deprive us of the ability to negotiate for 90 or 95% of the membership who voted for the union, with the expectation and with the union's obligation to fairly negotiate for them. So we think it's certainly a not workable definition and as close to meaningless as possible.
The bargaining unit that's involved in this case, that's like the graduate students at University of Iowa, I mean, aren't those people, there's tremendous turnover. Those people are, I have a daughter who's a graduate student, and I think they recently had a unionization election at University of Chicago. I don't know how it turned out, but anyhow, I think they all get paid virtually the same thing. Am I incorrect? Am I wrong about that?
There are steps and there are different processes there on how much they get paid with respect to the University of Iowa. They do have differences here. And we would only negotiate the lowest base rate. New employees, new individuals is all we could negotiate for here.
Mr. Gribble, I want to make sure I understand something you said. Your first statement was you have an obligation to represent all. I understand that. And then you gave an example of a unit of 100 and turnover of 10. You said you cannot negotiate in a meaningful way the base rate without the parameters such as the work to be done. Instead of asking the state to be the one to give you those parameters, couldn't you instead negotiate with some assumptions that you let them know, we're saying base rate should be X, and we're basing that on such and such? Why must there be something by the state, which would be technically a permissive area of bargaining?
We could, Your Honor, but PERB has held that that's not an illegal subject of bargaining, but a permissive one. In other words, we could condition our proposal on that, but the employer would not have to respond in that manner. The employer could respond in saying, we're going to address only your proposal on wages. You want $45,000 a year. We'll respond to that. But we're not going to respond to your request for 10 sick leave days and 15 days of vacation, because we don't have to do so. Those are just permissive subjects of bargaining. So you're right, there'd be some employers who would, Your Honor. I'd certainly say that there are, but there are also other employers who would not.
I'll pay for this, but I guess what the point I was trying to make is not so much expecting a response for them, but more or less as an explanation to them as to how you came up with your number. That in and of itself, you're saying is non-workable?
No, I'm saying you certainly could say this is how we came up with our number, but as a practical matter, the employer would not have to respond. And if the parties could not agree, then the only subject that would go to arbitration to be decided by a neutral would be that subject of base wages under PERB's interpretation. We could not take anything else. We could not take those assumptions that the $45,000 is based on 10 sick leave days and 15 days of vacation to arbitration. So we couldn't do that. So the question is, what is the employer obligated to do under PERB's definition? And the answer is not very much. Justice Mansfield, I concede that under your argument there's a greater turnover in that particular unit than there are in some others. But still, it would be relatively small. And still, our argument is that we have to have the ability to negotiate for all, that that's the obligation that's imposed upon us by law, and that we have to set the parameters with respect at least to the days for vacations and holidays, sick leave, not the particulars. The employer could still control all of those. Whether you have to use your vacation all at once, how long in advance you have to apply for it, whether it's taken in increments of 1 day, they'd have to do, and they could do all of that unilaterally. If there are further questions, otherwise, thank you very much.
Mr. Gribble, thank you as well. Ms. Makar.
Good afternoon. Diana Makar for the Public Employment Relations Board, and I will be yielding some of my time to co-counsel for the state. I just want to say something briefly as far as PERB's position and then clarify, I think, the two big points that Mr. Gribble just discussed for UE. Following the enactment of House File 291 amendments, PERB interpreted base wages for proposals presented in 3 cases. First in the Columbus case, followed by Oskaloosa, and then in this case, United Electrical in the state of Iowa. The UE case builds on those 2 prior cases. These decisions speak for themselves. PERB came up with what we think is a reasonable interpretation of the new 20.9 section base wages. However, we do not care if this court adopts this definition. If this court does not like it or thinks it's erroneous, then we respectfully ask that you give us a clear definition to apply for future cases. Now, with respect to 2 things that was just discussed by United Electrical, first is the starting wage. And if you look at the Oskaloosa case, it says that the base wages is the minimum salary common to all employees in a given job classification. Justice Mansfield, I think your interpretation was correct. There is a proposal in this particular case, for instance, where the year 1 base wages is $30,000, year 2 is $32,000. Just as an example, the component of that would be $30,000 base wage. The $2,000 would represent longevity. So everyone in a given job classification would, in fact, have base wages as a component of their entire salary.
Well, let me just follow up on,
Sure.
on that. Doesn't the whole idea of representing a group kind of fall apart when you are limited to only negotiating for the starting salary in any particular group of employees?
It does severely restrict the scope of bargaining for non-public safety units, yes.
Well, are you effectively bargaining for the interests of prospective employees instead of the group of employees that you're representing?
Well, everyone in a certain job classification would get a benefit of an increase to the base wages for that particular job classification. So it would affect everybody. It would just be the additional pay, including longevity, which is also referred to as automatic step increases. I think ISEA had referred to it as experience. Those things would no longer be mandatory. Certainly it'd be up to the employer now to determine whether or not to augment that base salary.
So an existing employee, if they negotiate a base salary for a new employee, that's going to benefit an existing
Well,
employee?
everyone in that particular job classification would get that base salary and any increase that's negotiated by the union.
All right.
Yes.
And that's the position of PERB?
Yes, it is. And the second part is about the information that's needed to bargain. And it's well established in the private sector and the public sector that an employer's duty to bargain in good faith includes the duty to furnish the union with information. And PERB has this in established case law. And here is the standard, is that the information must be clearly specified by the union. And two is that it may be relevant to bargaining or the administration of the contract. We have lots of cases, just off the top of my head, case number 6541. You look at them up on our database search system, and you'll find a couple of pages of those information request cases. So there is, in fact, a standard that applies that PERB has enforced. And second of all, I liken the request for information as to how the parties have historically done this with insurance. The parties have required the renewal premium rates from the insurance company and cannot bargain the employee share of the insurance and the employer share of the insurance unless they get that information or until they get that particular information. We are not expecting the unions to bargain blindly, but in fact make these information requests. Under our interpretation, there are permitted subjects of bargaining, yes, but that does not preclude the employer from providing the information that's needed and on which the union can premise their proposals.
You can also decline to provide the information.
If there's, and the cases speak to that because it is grounds for a prohibited practice. And I think it was clear in each one of these three cases that I had cited, starting with Columbus, Oskaloosa, NUE, reiterated again and again. This, some of these things may be permissive, but it's incumbent upon the public employer to provide the information necessary for the union to make informed decisions, make informed proposals for bargaining.
Okay, so if I understand it, your position would be that the additional information beyond base wages can be permissively provided, and if you don't provide it and you undermine the bargaining position, it's an unfair labor practice.
Yes.
About Waterloo 2, let's talk about the second issue. Waterloo 2 seems to stand for the proposition that you have to know kind of what you're bargaining for in order to understand what your wage rate is. You take a contrary position, I think, but help me out. I mean, so you heard the argument. They're negotiating a so-called base rate, but how, what the sick leave is, what the what the vacation days are is relevant in determining what the impact is on base rate. You understand the argument, please?
Sure,
Yeah, please.
and it was cited several times by UE, and we use Waterloo 2 as a guide in our analysis in that two-pronged test. Obviously, we can no longer interpret the section 20.9 subjects given their common and ordinary meaning, but we think that that test that you had written survives, just that they have to be interpreted in a narrow and restrictive.
Is this language the language in the declaratory order that bears on it? You say, your client says the employer's obligation of bargain in good faith requires that it inform the organization whether those conditions of employment will exist at all for the term of the agreement being negotiated, and if so, the quantity or extent of those the employer will provide in its discretion only when it knows the content of an honest day's work. I think that was my colleague's expression from Waterloo too.
Sure.
Will the employee organization be in? So
Sure.
that's the PERB's position, is that it has to be disclosed as part of the obligation to bargain in good faith, right?
Sure, and that follows our interpretation. The list, there were 18 subjects that were taken away for non-public safety units. 12 of them, we believe are permissive subjects. 6 of them are now specifically excluded for non-public safety units. So our view is that those 12 are permissive subjects, but the employer is obligated to provide information on them so that the union can make informed proposals that are meaningful. Any other questions?
Yes. So I'm troubled by the notion that if we're not including step increases or longevity, that more people who have been around more than a year already have. If that's not part of base wages, couldn't you have sort of a shell game where the employer negotiates on the base wage, maybe offers an increase, and then just simply takes away that amount from a step or longevity?
You're absolutely right. Now, as a practical matter, will the employer lose that tenured employee who made $85,000 and now is making $30,000? But you're absolutely right. That is the effect of this.
Do you wish to yield the rest of your time?
Yes, thank you.
All right, thank you. Ms. Weber. Thank you, Ms. Makar.
Thank you, Your Honor. May it please the court and counsel. My name is Molly Weber on behalf of the interveners, the state of Iowa and the Board of Regents. The interveners contend that this court should affirm because the proposals at issue are permissive subjects of bargaining. Now, I just want to hit a couple of highlights. I'm not going to reiterate everything that my co-counsel has argued, but obviously the amendments in February of 2017 to Iowa Code Chapter 20 changed the landscape significantly. I think we all recognize that. And there's 3 changes to Iowa Code Section 20.9 that were made that are important to this case. The legislature restricted the mandatory subjects of collective bargaining for this group of non-public safety employees to base wages, and second, set up a distinction between the laundry list of items for the public safety employee group and the single base wages item for the non-public safety employees. So I think you have to look at it in context of that distinction. And third, there's that explicit language that's added stating that the mandatory subjects shall be interpreted narrowly and restrictively. And as you know, that legislatively then overruled the common and ordinary meaning of Waterloo II, and we went back to the pre-Waterloo II era when the Iowa cases, the Iowa Supreme Court cases from an earlier time had already done that, the narrow and restrictive meaning. So it went back to that that time period. These public policy judgments and decisions were already made by the legislature. And United Electric is trying to undo the policy decisions by arguing for interpretations that, in its briefing, I think it used words such as meaningful, reasonable, those type of words. And it's an argument that's best left for the legislature because we have to go with the meaning of the words that the legislature used. Now, just following up on a couple of points the petitioner made, there was this case, a few cases that were cited by Mr. Gribble on the duty of representation, such as Norton versus Adair County. That's an Iowa Supreme Court case from 1989. That case, as I recall, cites Iowa Code, section 20.17.1, but it doesn't say that it's each and every, that the obligation is to represent each and every individual member of the bargaining unit. It cites the legislative language in that section says, shall represent all employees fairly, or sorry, shall represent all public employees fairly. So I think it's a bit of an overstatement to imply that that duty to represent.
On this duty to fair representation, isn't it also true that sometimes, in fact frequently, employees, even ones within the same bargaining unit, move from one job classification to another?
That's true, that does happen.
And in that case, they would then get the benefit of a different base wage, whatever it was, for that other job classification.
Yes, Your Honor, I believe then that once they move to a different job classification, then they're subject to a different minimum base wage for that job classification. So I think, again, that may be an overstatement to imply that it needs to be done on an individual basis for each member. Also, to follow up on Mr. Gribble's argument about the hours and the vacation and so forth, those are still in the statute in 20.9, as you know, for the public safety employees. So it says to negotiate in good faith, those are mandatory topics, hours, vacations, insurance, holidays, leaves of absence, and so forth. Those listed items are not even in wages for the public safety employees. So it's unclear how they could be separately listed, not in the category of wages, the general category of wages, but then somehow would be included in the more narrow term of base wages. It just can't be the case that that would have been the intent or the design to set it up that way. I think, again, Waterloo 2, the discussion about that, there were a couple key changes. It's a valuable case. Justice Appel's case is, set forth this test, and it's still valid, but there's the key changes we have to recognize, that it was defining wages, and the change now to base wages takes us a little bit beyond what's in that case, and then no longer having the common and ordinary meaning test, that we've now got this additional legislative language. So I think we still look to that case for the guidance in the test for what we need to do, but we also have to recognize the differences that have happened since then. And it's collective bargaining, not individual bargaining. So as far as the idea of individuals, again, I think if you look at the whole structure of the way it was set up, in the cases on the duty of representation, they don't say it has to be, each individual member has to be represented. Or bargained for, I guess I should say, through mandatory negotiation. So we didn't really talk a whole lot about the point on the arbitrator's authority, but with regard to the question of the arbitrator's authority, a reasonable interpretation on that is to view the expiring collective bargaining agreement as still current, and so that it's not a past CBA. And I think that was explained fairly well in the briefing. Any other questions?
Thank you, Ms. Weber.
Thank you.
Mr. Gribble.
Thank you, Your Honor. Believe what you've heard from IPERB is not supported by the decisions that they've reached here, particularly in Oskaloosa, that all that is mandatorily negotiable under their ruling is simply the first step of any job classification as unilaterally determined by the employer. Now, it may not make a lot of difference, but the proposal that we had here, one of the hypotheticals, was proposal 3, and we had a pay grade starting with year 1. Someone would make $30,000. By year 5, they'd make $46,000. PERB ruled on that, saying that the minimum salary for year 1 is mandatorily negotiable. The remainder of the proposal is a permissive, subject to bargaining. To me, that means you can negotiate only for step 1. Even under PERB's interpretation, which I think today is different than what their ruling says, for anyone else in the bargaining unit, you could not negotiate their pay. I think we all know that there's a wide range from a first-year teacher to a 10th-year teacher, or a first-year social worker to a 15-year social worker. So as a practical matter, their salary perhaps might be at $65,000, and if you could only negotiate the first step at $35,000, they would receive a $30,000 increase, or decrease, excuse me, in pay. So to me, it would be just as meaningless as what we believe PERB has held, and that is you can just negotiate for the initial proposal, the initial wage rate in any job classification. I think the impact on the employees is the same. You can't negotiate for anyone but a new employee. Otherwise, PERB is saying, well, sure you can. If they will get $30,000 instead of $65,000, but you can't negotiate anything more for them. So I think while we still disagree with PERB's interpretation that they've given to the court here as compared to their decision, the result, I think, is virtually the same. You can't negotiate for anyone other than new members of the bargaining unit. You can only negotiate their wage rate of pay. We think you can't negotiate for anyone else. PERB says, sure you can. Today they're saying that, but you'd be stuck with $30,000, not any more than that for those groups. With respect to the argument again that PERB is saying, well, the employer would have to supply information as to number of vacations or holidays or sick leave, again, PERB does not cite any authority for that. The existing case law on those subjects where someone has requested information, PERB has applied a fairly liberal discovery standard to those requests, but it said it must be related to one of the mandatory subjects of bargaining. It used to be 17 and still is for the public safety employees, but for the non-public safety employees, it would just be base wages. There is nothing in the law, nothing in PERB's prior decisions that would indicate you could force an employer to provide information on those subjects on which they have no obligation to negotiate.
Well, but I may have misheard it, but I heard them saying that, well, for example, vacation and so forth is now permissive, but if they didn't give you that information in order to allow you to negotiate a base pay, that would be an unfair practice. I think that's what I heard them say.
Yes, that is what PERB is saying, Your Honor.
And if that were true, that would get you where you needed to be, would it not?
It would not. It still would not, and for the reason that a prohibited practice starts with an administrative law judge. It then goes to the full board, then to district court, and on to the appellate court. So it still would not in any way give us what we need. That would be a 2-year process. As we said, the bargaining is between November and must end by March. So it would not be an effective remedy, even if what PERB is saying is true. And we don't believe you'll find, I could not find any case law to support an obligation to provide information on permissive or non-mandatory subjects of bargaining. To sum up then, we think that it's important to have a definition that allows us to negotiate for everyone in the unit and to negotiate the parameters of the work to be done for the wage rate requested. Thank you.
Mr. Gribble, thank you as well. Ms. Makar, Ms. Weber, thank you. The case of United Electrical versus PERB is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.